For the record, Senator Brian Collmore, representing the Rutland District. This is a bill that originated in the Senate and has to do with the open meeting law. We made some changes to it at the request of various entities and sent it along to the House. And they came back with suggestions of amendments. I think there were 8 in total. And the one that much concerns this committee here has to do with the disorderly conduct provision. Just to set it up, it was introduced by Representative Jim Harrison, who represents the Mendon District. Town Hall there has had to close on occasion because of one individual who shows up, I don't want to say every day, but quite often, and is disruptive. Meetings aren't necessarily going on when he shows up, but he's disparaging of some of the folks that work in the town offices. And so they felt it prudent to close whenever he showed up and not be able to do a lot of work. So he's very concerned. I don't know whether this happens in other communities around the state or whether other meetings have been interrupted. But, and council is here as well. So section 4 and section 5 of the bill have been amended by the House. And in section 4 is the intent of the General Assembly. Section 5 of this act amend Title 13, Section 1026 to conform subdivision A4 of that section with the constitutional requirements that are articulated in the Supreme Court decision. I believe it was 2008. The 2009 was when the decision was rendered, and it's the State versus Colby decision, and expresses the intent of the General Assembly that it would amend the disorderly conduct statute. And then it goes into more detail in section 5 that indeed a person is guilty of disorderly conduct if the person, with intent to cause public inconvenience or annoyance or recklessly creates a risk thereof without lawful authority, disturbs any lawful assembly or meeting of persons, or as used in this section, disturbs any lawful assembly or meeting of persons means conduct that substantially impairs the effective conduct of an assembly or meeting, including conduct that, and there's 2 conditions, either causes an assembly or meeting to terminate prematurely, or consists of numerous and sustained efforts to disrupt an assembly or meeting after being asked to desist. And the meeting clearly includes only a meeting of a public body, as those terms are defined in Title I. So, as I understood from council, this is already in law, but the specific reference to the Supreme Court decision allays the fears of some law enforcement officers and some Board of Aldermen, Board of Select Board, whatever it is, to, in essence, be able to do something with a person that is just continually trying to disrupt the meeting. So it's a clarifying provision, I think, more than anything. And I'm sure Attorney Anderson will let you know a little bit more legal terms whether I've captured the intent of this provision. Senate Government Operations Committee, with possibly one exception, I think, is ready to concur with the other provisions of suggestions made by the House. But this one seemed to be sort of outside what we have even considered in our meeting. So that's where we are on it. Again, I don't know how frequent this happens, but it seems like if you look at YouTube a lot, there's always a meeting somewhere that somebody stands up and starts yelling and hollering and are asked to stop, and they don't. And then people come in and usher that person out, or the meeting ends prematurely without anything being done.
Well, thank you for the context of this. And, you know, I mean, I read through the State versus Colby case during lunch, and I mean, there's even a line on page 4, well, paragraph 8, says that they find that the disorderly conduct statute as worded impermissibly sanctions a substantial amount of protected speech, even when considered in relation to its legitimate scope. And, you know, oftentimes issues of vagueness and overbreadth is an issue in legislation related to fundamental rights. And so, you know, with this one, we're dealing with the First Amendment of protected speech butting up against freedom of association. So, you know, I can see how the language basically being copied and pasted from the decision into the statute addresses the overbroad issue. But yeah, no, thank you.
Yeah, no, I think you captured that pretty well. It's always a balancing act to consider First Amendment rights versus people getting together to get something done and being interrupted. But I think the two conditions that are present, as you said, carve out a piece that I think we can flip with, at least my committee would, but glad to bring it forward here.
Thank you. Senator.
And one of the things that allayed my concerns about it was, as I understand it, somebody is disruptive, then they're warned. Then after that, it has to be sustained disruptions. So for instance, if somebody's screaming and then they're warned, and then they scream once more, they wouldn't necessarily fall to this. It's once it becomes undeniable that they won't let the meeting continue.
Yes. Causes an assembly or meeting to terminate prematurely. And again, I'll have Tucker Anderson
It's
probably
those last
explain that.
mentions that I was referring to.
Yeah. So, I mean, it is open to interpretation, I'm sure. Someone could say, well, it was just my exercising my right to free speech. It really wasn't disorderly. It wasn't intended to be offensive to anybody. I just was strident in my, expressing my opinion and my views. But at some point, I think if a public body wants to continue to do work, they have to be allowed to do that without constant interruption and interference. But I'll certainly yield to Tucker, and if folks on this committee continue to have issues, we'll probably strike it and then send it back to the House and recur with the rest of what we have, and we won't.
Thank you.
Okay.
All right, good afternoon, Tucker Anderson, Legislative Council. You heard a great overview and description of sections 4 and 5 of S59 as passed by the House. For some of the background, and the chair already started to get into it. Subdivision A4 of 13 VSA section 1026 already allows for an individual to be cited for disorderly conduct when, without lawful authority, that individual's actions cause a disruption of a lawful assembly or meeting of persons. The problem is that in State v. Colby in 2009, the Supreme Court of Vermont said, and you put this very accurately, that was overbroad and it captured a whole swath of protected speech and was likely unconstitutional. So the court ordered that section of Title 13 a construction that would meet constitutional requirements. And the construction that the Supreme Court of Vermont put together for 1026 subdivision A4 is exactly the language that the House has now put into the statute, defining those terms in A4. The intent, as expressed in section 4 of the bill, is just to do that, to conform the disorderly conduct statute in that subdivision to the State v. Colby holding, and to communicate primarily to law enforcement officers and the communities that are dealing with these issues what the state of the law is. And the reason that House Government Operations and House Judiciary decided to do this was that there was quite a bit of testimony on the record about concerns over enforcement, particularly with respect to open meetings, and whether or not it was even a context where this sort of disorderly conduct citation could be applied. Happy to give you as much background as you would like about State v. Colby, the words on the page, the issues that arise here. This is definitely a let's break out the popcorn issue for attorneys because of the conflict between First Amendment interests and rights that arise in this setting. You have primarily discussed when Senator Collmore was giving the lead up in discussion, the First Amendment rights of the individual might be disrupting the meeting, but there are conflicting First Amendment rights for others who are in attendance. primarily their right to speak in an ordered way before the assembly, and also their First Amendment right to assemble. And see that the business of the public body, if they are supportive of it, is done. And Stacey Colby did look at that tension. The cases that Stacey Colby cited heads, some of the foundation for their decision. Particularly in Ray K, which is a Ninth Circuit decision from the Ninth Circuit Court of Appeals, really looked at what is the tension between the First Amendment speech rights and assembly rights in these public meetings, and how is that balanced? And at what point is a threshold crossed where an individual's conduct, not the content of their expression, but the volume, persistence, and actions of that individual that disrupts the meeting to the point where they could be cited for disorderly conduct. I will say that heckling is almost certainly allowed in every context, and Ray K even said it is part and parcel of the democratic process that representatives from our government should be expecting a confrontational audience that will heckle them during the conduct of their.
I'm thinking of the Parliament in England.
Yeah.
Where Tony Blair or whoever has to go to the floor and then people yell at him while he talks.
Boo and hiss. Yeah.
The heckling piece is a little bit helpful. So, because what I'm trying to, and what I would understand that to mean is that if someone was asking repeated questions and told to stop asking questions, but continue to have questions, but was not yelling or screaming, or that would not rise to the level of the second problem there, the repeated disruption.
Some of this is going to be context specific. And the examples that I can't give you, the narrative from Stacey Colby, individual stood up, interrupted the speech. The interruption lasted about 30 seconds. The speech was 8 minutes long. The ceremony was 3 hours long. The Supreme Court said that was not substantial impairment of the effective conduct of the meeting because it was such a brief period of time. One of the things that you might be looking at here is that the current state of the law for the open meeting law only allows public participation around the items on the agenda of the meeting, what the business or matters of that meeting are. That's what public participation under that subsection in 1 VSA 312 is supposed to be constrained to. So if the questions are sustained, disruptive over a long period of time and don't relate to the business of the meeting, and either continue for such a long time that you get the second prong where the person is cited for their sustained meaningful disruption of the meeting, or where the chair under Robert's rules has the authority, and in this case the desire to say we have to stop because the meeting cannot continue with this individual's actions being so disruptive.
My other question is if there is a different conflict, if it is an assembly, and so I'm thinking of, people assemble to protest the meeting, are they going to be cited with disorderly conduct?
That would be under the current state of the law, right? That these amendments wouldn't change that, and the answer is perhaps yes, because assembly currently is not defined at all.
But that's not a public meeting. That's warned and et cetera.
Right, but public meetings are just one example of the meetings that would fall under this
Under this or under the
disorderly conduct. So the current language that's in law is any lawful meeting or assembly of persons, which might include protests, but
we're now bringing the open meeting law, public meeting law under the rubric that's currently existing. We're just tailoring it. Yeah, correct.
Well, and so I don't know that I asked my question clearly, because the reason that some of these, I think you said quoted a Ninth Circuit case, is because there's a conflict between an individual's right to free speech and the right to assembly. Now, what if we were talking about a conflict between a public body and the people to assemble?
it could be
Well, I mean, a protest on the State House lawn is people assembling. That falls under the right to assemble. So if a bunch of people came together to protest a public meeting, they both have the right to assemble.
If I'm, reading the fact pattern correctly, you're talking about some meeting of a public body happening, and then in a separate space, there's a protest happening that
Perhaps not a separate space.
if it disrupts the meeting, it could fall under this. Yes,
Because we
But
have
it already does fall under it.
correct.
So I think so even if this law were to pass, the same elements would have to be met if the prosecution were to prevail. You know, the way I'm looking at this, I think in response to the hypothetical, which is a very real situation that but you know, this, you know, State versus Colby, you know, it talks both about brief outbursts and long, lengthy outbursts. And that if the current law, as it's written, were to be interpreted, it would criminalize heckling, interrupting, harsh questioning, and booing. And all of those are manners of speech that have been tolerated pursuant to the rights accorded to the peoples of free societies. And then they go on to say that the language as it's written in the current law is essentially unconstitutional. So, I mean, it's my own opinion that this is a good change because overbroad laws are usually not very good.
Is there also some rulemaking or policy setting included in the law for the town to make some sort of policy?
That is something that was proposed as part of Representative Harrison's bill, H
Okay.
45, that is not included here. I obviously can't speak to the policy decisions or the
Understood.
proposals.
But it's not in this bill.
But the committees that took a look at this in the House focused on this because it wasn't changing the state of the law.
Okay.
And reserved those other components, including the rulemaking and potential guidance from the state, as items that would be taken up in the future.
Okay, that is really helpful. I mean, I have concerns in general with disorderly conduct statutes for the same reason the Supreme Court currently does.
So are you?
I'm okay.
Okay, thank you.
Because and we got into this argument last biennium, I find it overly vague, but this does seem to clarify and narrow, so I think I can reluctantly sit with it.
Something to keep in mind is that currently under the open meeting law, the chairperson has authority to adopt reasonable rules for public participation. That would actually be binding for any individual's participation in that portion of the meeting. And, you know, so there already is some authority here for public bodies to set rules for public engagement around it. Some public bodies have robust public participation rules, such as time limits or constraining comment to agenda items. Some do not.
Again, as it's clarifying, like I have issues with the underlying disorderly conduct statute, but as it is clarifying, I think I'm okay.
Maybe any other questions or comments for Tucker?
Nope, I'm good with it.
Right. So it sounds like we're all good with this. You know, you guys-
Good.
So thank you for coming in on short notice. Appreciate it.
Thanks for having.
And Senator Collmore, if I'm happy to discuss our opinion on the floor.
Sure.
We're supportive of the change. And yeah, this.
Yeah, I think I'll let Pro Tem and the Secretary know that GovOps is going to concur with all the changes. And then after that, you could just stand up and say that that particular provision was taken up earlier today, took testimony from Ledge Council, and we're also Strabo 5-0 are supported.
Yeah, great. Thank you. Appreciate it.
Thank you.